Good afternoon to everybody who's joining. Welcome to our first Legal Tuesday of 2021, and this couldn't be more timely. We have Ashley Gonzalez with Brewer, Offord, and Pedersen, who's going to come on in just a few minutes and give some updates on evictions and all information for landlords, tenants' rights, updates. I believe Ashley said AB 91, which is going to be voted on this week. So if you just give us a few minutes, we'll get started. We'll let a few more people come in. And then we will get started. I will say we are going to be recording this session, so you can go back and listen to it. You can share it with any colleagues that maybe weren't able to join. And you can also put into the chat or the Q&A any questions. Please note, because there's a lot of information, we're going to save all of those questions for the end, so your question might get answered as we're going. So again, we're going to get started in just 1 second with Ashley with Brewer, Offord, and Pedersen. But you are in the right place for eviction updates. So I'm going to welcome Ashley with Brewer, Offord, and Pedersen. She's going to give some updates on what's going on in the eviction world, which, as you know, information came out yesterday. So Ashley, if you want to take it away.
Good afternoon, everyone. Thank you for joining. I see a couple more people rolling in, so we'll get them caught up as we go. But Jody is right. Yesterday, Governor Newsom announced that they do have a tentative agreement by way of Senate Bill 91, which is essentially an expansion of AB 3088. If you were familiar with the terms of AB 3088, we've done some presentations previously on this. It's the Tenant Protection Act of 2019. Senate Bill 91 will, to summarize it, extend all those protections to at least July for the most part. So I wanted to cover that. The Assembly and Senate are scheduled to vote on this on Thursday, and they anticipate that it will be passed. From my review of the recent notes on the bill, it looked like only one person had voted against it, so it was widespread approved. It's just a formality at this point. So most of what we're talking about today will be in effect as soon as that passes and goes into motion. Previously, AB 3088 was set to expire at the end of this month. So there's a lot of anticipation, a lot of preparation going on, especially in my office and my clients, where the protections were ending January 31. And so there was a time period wherein tenants previously had to pay 25% of rent for certain time periods by January 31st. And if they did not, you can evict as early as February 1. Now, that's going to be pushed back, or it's anticipated that it will be pushed back. So we'll talk about that, and then other things that will be added by Senate Bill 91 and things to consider just depending who you represent. If you're a landlord, property manager, even if you're a tenant, it's good to know all the things that are coming. So one of the key takeaways that I saw in Senate Bill 91 was that there is a $2.6 billion federal relief program by way of a rental subsidy. Essentially, what the bill says is that landlords will have the opportunity for rent accumulated from April 2020 through March 2021 to receive 80% of the rent that's been accumulated. Now, there's some conditions with that acceptance of federal relief. Number one, you have to forgive the remaining 20% of the rent owed by the tenant. And then you also have to forego evicting them for that unpaid rent. So you essentially will get 80% of what is owed. You have to forgive 20%, and you can't evict for that remaining amount. To qualify for this assistance, your tenants have to earn less than 80% of the median income. To give you some perspective on that, in 2020, for two people in a household, 80% of the median income was $89,000, $750 income per year. That's total. So both of them combined, if they both work. So if they earn less than that, you will qualify. Obviously, if there's more people in the household, that amount is higher. You can contact me and email me after this, and I can send you the median income information depending on what county. But that was just for Santa Clara County. Since this is SCORE, I wanted to give you that information. Per Senate Bill 91, you can begin applying these funds as early as March 2021. If you deny the forgiveness, you can still recover rent, but the tenant is obligated to only pay 25% of the rent owed. And I'll talk about the timeline. So there's some pro con balancing here for landlords. You can either accept this 80% subsidy, forgive the 20%, or you can pursue all of the rent in different stages. So what Senate Bill 91 does is that for rent owed from September 2020 through June 30, 2021, the tenant has to pay 25% of the rent owed on or before June 30th, 2021. So previously it was January 31, as I mentioned. Now it's been extended to June 30. So they have to pay 25% of the rent accumulated from September 2020 through June 2021 on or before June 30th. So you can collect that. If the tenant does not pay that 25% by June 30th, you can evict as early as July 1. Now, what about the remaining 75%? You're probably wondering, well, you can pursue that in small claims court, but you cannot file that action until August 1, 2021 now. That's been extended. So basically you have to decide, do you want 80% for sure from the federal government assistance program, forgive the 20%, or do you want to wait until the end of June, see if you get 25%? If you don't, evict. And then if you do get 25%, pursue the additional small claims. That can be difficult collecting from a tenant. If you've ever evicted a tenant or gotten a judgment against tenants, you know that it's just a piece of paper at the end of the day. The difficulty comes in actually collecting the money on that judgment. So it's definitely uncertain compared to the 80%. So you would be able to pursue that money, but you would have to collect it on your own. And the likelihood of a tenant paying you is next to none, at least in my experience. It's very difficult to collect against a tenant. Also, you have to deal with the court system the way it is right now. I'll talk about it a little bit later, but right now we've seen a huge delay with eviction trials, because what tenants do, or they tend to do if they're savvy, is they request a jury trial. And right now there's a huge shortage of jurors due to COVID and the restrictions. Maybe that might be lifting now with the stay-at-home order being lifted, but there's definitely delay in filing eviction, and it's uncertain that you will be able to collect. So you'll have to balance whether to take the 80% or go that route. What Senate Bill 91 also does is it provides a statewide moratorium that's uniform. And what the bill states is that any city and county moratoriums cannot extend the protections longer than the state protections. Previously, it was ambiguous and confusing on which applied, the county or city and the statewide moratorium. Senate Bill 91 says no, this is the moratorium. Any city and counties cannot extend it past these time periods, and this is the one that applies, which I think the California Apartment Association was really asking for. They really wanted clarity on having one uniform moratorium, and this is what that bill does. Also, as I mentioned, they extend COVID-19 rental debt being from March 2020 through now June 2021. If any notice to pay is given for this time period, you have to provide the tenant with a declaration of hardship related to COVID-19, and they can execute that in order to be protected by Senate Bill 91. Important time periods to make note of, which we've explained before: March through August 2020. If the tenant signs a declaration for that time period, The rent is never owed by way of an eviction action. You can collect that rent in small claims, but you can never evict the tenant for that non-payment of rent for March through August 2020 if they sign the declaration. For September 2020 through June 2021, if they sign the declaration of hardship, again, they have to pay 25% by June 30, 2021. Again, you probably want to know if you have any tools to combat this. One thing you can do, if you have documentation that the tenants are high income, and you have to have proof of this, you can't just have a hunch or a belief that, they work at Facebook or they work at Google, and I know that they're high income. No, you have to have proof in their rental application or some documentation showing that they're high income. And what the statute defines that as the household earning 130% of the median income for the county. I'll give you another example. For two people in Santa Clara County, being high income would mean that they both make more, or collectively make more than $147,290. So if both their incomes combined are above that $147,000 value, and you have proof of that, you can require the tenant provide documentation that they have been affected by COVID-19. So it does add that extra layer of proof compared to just signing the declaration under penalty of perjury. So that's important to know. One drafting tip for these notices to pay and the declaration forms is make sure you're using the current forms. When Senate Bill 91 passes, CAR has a really good system. If you use zip forms where they update the forms live, you don't want to use old forms because all of the language in there is changing. So you want to make sure you actually upload the current form. I anticipate they'll change those and the language in the notice to pay forms this week or shortly thereafter, Senate Bill 91 passing, but make sure you're not using the old forms for the old time periods that March through January 31. You want to make sure that the language is included through June 2021. A couple other things, as I mentioned, small claims actions can now not be filed until August 1 compared to the previous deadline. Until July 1, 2027, and this is a new requirement given by Senate Bill 91, the landlord has to provide a declaration or some kind of documentation when they file a complaint, either to collect the rent or to evict the tenant, that they've tried to assist the tenant in obtaining rental assistance. So this is a new requirement. It's definitely foreign to me. So anytime my client wants to pursue that rental debt or evict the tenant when applicable, you're going to have to provide information or an email or some kind of documentation that you try to lead them to get assistance, or you help them, or you explore the capabilities. So that's super important to know, because if you don't, as a landlord or property manager, the court is authorized to limit your damages and the amount that you can recover. So you really want to make sure that you abide by these new rules and that you help the tenant find assistance if it's available to them. And that includes, if they're below that median income that I mentioned and things like that. I could provide more information on that. I presume that they'll talk more about rental assistance programs once it actually passes. I don't have a ton of information on that yet, but that's yet to be seen. Also, they put limitation on the amount of attorney fees you can recover by way of Senate Bill 91. For uncontested matters, it's $500. For contested matters, it's $1,000. So that's a fairly low cap if you've ever experienced any kind of action against the tenant. Another protection is that UD records will be automatically masked until July 1, 2021. Previously, if there was a judgment entered, 60 days after that was entered, unless there was some kind of language asking the court to mask the record, that would be released. Well, now they're keeping those private until at least July 2021. Another rule added, you cannot use the security deposit towards active COVID-19 rental debt unless the tenant consents to that use. You can use it after the tenant vacates by way of Civil Code Section 1950.5, but you cannot use it during the lease. So make sure you don't do that. And then there's a couple other things for if there is existing COVID-19 rental debt. What Senate Bill 91 says is that on or before February 28, 2021, you have to provide an additional notice to the tenants of this new law. So if there's existing COVID-19 rental debt as of February 1, 2021, which is coming up next week, you have to provide them with new notice. And there's various civil code sections that have changed by way of the Senate bill that's, like I said, anticipated to pass this Thursday. But you want to give the tenant the new language that any rent from September through June 2021, you have to pay 25% of that on or before June 30th. So they won't allow you to pursue that unpaid rent unless you provide this notice on or before February 28, 2021. So that's super important to know. If you have existing COVID-19 rental debt owed by a tenant, you want to serve this new notice. I can help you do that, or I can lead you in the right direction. Just let me know. But this is all coming down the pipeline this week. One important distinction before I go into more detail on the specific changes is that Biden recently extended the federal eviction moratorium through March 31. I'm sure you may have seen that in the news. But he's also urged Congress to extend that through September 2021 as well, but that has yet to happen. Keep in mind, though, that if California is more restrictive or protective of tenants, which it is, that will apply. So until the federal protections become more protective, you really just need to worry about the California protections, which will be Senate Bill 91 coming up, previously AB 3088. So just keep that in mind. Now on to some specific changes. There was changes made to Civil Code Section 789. And now what the bill changes is that you cannot use the fact that a tenant has unpaid rental debt that's been affected by COVID-19 as a negative impact when reviewing their application or submitting a review for a future landlord. You essentially cannot, a tenant cannot be punished for not paying rent if they're protected and they otherwise wouldn't have to pay under the bill. So that's one important change that the SB 91 did. And then unpaid COVID-19 rental debt cannot be sold or assigned until July 1, 2021. I haven't heard a lot about assignment or selling of the debt yet, but I presume that's coming down the pipeline. But you want to make sure that you refrain from doing that until at least July 1 of this year, unless it's extended further. Previously, that civil code section only provided for statutory damages if the landlord filed an action or sought the rent after you sign a declaration. So that it expanded it quite a bit. Another change you might want to note is Civil Code Section 1942.9. If the tenant has submitted the declaration of hardship, landlord cannot charge a late fee or increase any other charges previously not charged to the tenant. Now, that may be a little bit confusing to some, but I'll explain. For example, if you're a landlord and you previously didn't charge for pets and you ran into trouble with your tenant paying rent and they signed the declaration of hardship related to COVID-19, you can't now charge a pet fee to try and make up for that difference in the unpaid rent, even though the tenant is protected. That will be seen as retaliatory. That's kind of common sense, but you have to make sure that anytime a tenant uses a right available to them or exercises some kind of statutory exemption or anything that gives them protection, you cannot then charge them more or increase anything based on that ask or that exemption or that protection. So just be very careful with that. And then I talked a little bit about changes to small claims actions. I think this is a very important one. Typically, you're limited to $10,000 in small claims. Now, that jurisdictional limit has been removed, at least temporarily. But again, you cannot file till August 1, so you will have to wait in order to recoup that rent. And this is for unpaid rent all the way from March 2020 through June 30th, 2021. You can, like I said, you can seek the total amount of rent owed, but what you can evict on is a different story. So small claims will be available to landlords for all unpaid rent, while evictions will be available to landlords for tenants who either didn't pay that 25% for the time period I mentioned or didn't sign the declaration or something like that. So one important thing to know is that the courts added this rule to Senate Bill 91 because they want to litigate these matters very quickly. Typically, a civil action, I would be saying it modestly, would take anywhere from about 2 years to 2.5 years with the current state of the court, with all the closures and the delays. So small claims is definitely the way you want to go. It's much faster. There's also no attorneys allowed in small claims, so it's typically a little bit more or a little bit less contentious, excuse me, and then you don't have to pay attorney's fees. So that's very, I think that's very advantageous to landlords. Also, there's no limitation on the amount of small claims actions that you can file, where previously it was anywhere from 2 to potentially more depending on your status. Now the way the statute reads or will read is that it will be unlimited. So I think that's a powerful tool and something to use. One big change from AB 3088 to SB 91 is that actions must include documentation showing that the plaintiff has made a good faith effort to either investigate whether government rental assistance is available to the tenant, seek government rental assistance for the tenant, or cooperate with the tenant's attempt to obtain rental assistance from any government entity or party. So you have to show documentation that you either did it affirmatively or you helped the tenant in their efforts. So that's a big change, in my opinion, something that you want to include in your actions. Make sure you do that. And if you don't, the court can limit how much you can recoup. Also, for notices served or on or after February 1, 2021, if the tenant, like I said, signs the declaration and pays 25% of the rent by June 30, 2021, you cannot evict for that unpaid rent. One thing that you can do for tenants and put pressure on them is you can require a tenant to provide a declaration for each time period that rent is owed. So for example, you can require a declaration of hardship for January 2021, February, and so on. It's not just one set declaration. So if you have a high income tenant and you've had them sign a declaration and provide proof, you can continue to do that per the statute. So I think that's important because a lot of people either have gone back to work or have obtained work. So if you want to try and put the pressure on the tenants, that's one way you can do that, is to require them to sign under penalty of perjury and potentially provide documentation that they are still affected and that the circumstances are the same. I think that can be a powerful tool for landlords under these new changes. Some other changes, again, back to September through June. This time period is the major adjustment. There have been rumblings that this may be extended even through September 2021. So brace for that. And going back to the federal assistance, it may be something you want to consider even more as a landlord because with the state of COVID and the way things are going, I know we have vaccines coming out. But there's been evidence of new variants and new strains. And so it's really uncertain how long these protections can go into effect. So accepting that 80% subsidy may be a good situation for you. And I did a little bit of math to try and help landlords make this decision. So I gave an example where rent was $5,000 and the tenant has not paid from September 2020 through June 2021. So I had the total amount of rent due as $50,000 per the statute. They would have to pay $12,500 by June 30, 2021 to avoid eviction. That remaining 37,500, as we discussed, can be sought after in small claims court, but again, you have to file an action, you have to wait till August 1, and on top of that, you have to collect. So, to find a tenant that has an extra 37,500 when they're already not paying rent, they're struggling, and trying to collect on that, in my opinion, would be very difficult. Again, compared to the federal assistance provided, you could receive up to 40,000 instead if you forgive the other 20%, the 10,000. So just some math comparisons here. For the time being, they're saying that only a certain time period is recoverable up through, I think, March 2021, dating back to March 2020. I think they're still trying to establish where that federal funding will be applied to, and whether that will extend through June 2021. Certainly it should by way of the bill and the way it's drafted. But I think for the time being, it's only for a set time period. But we'll see when they actually sign it into law and it comes into effect what that program will look like, but just keep that in mind. Again, until July 1, 2021, the following evictions are allowed, in addition to the ones allowed after that if the tenant doesn't pay. Tenants that are guilty of an unlawful detainer before March 1, 2020. So if your tenant has unpaid rent from before March 2020 and you gave them notice and they didn't pay, you can evict on that basis right now, or any other unlawful detainer cause. Another reason is tenant failed to provide the declaration either timely or efficiently, or they didn't provide documentation. Essentially what happens is you serve this 15-day notice to pay with the declaration form attached. And if they don't either pay the rent owed or provide the declaration within the 15 days, and do note that it is 15 business days, so it's not calendar days like it previously was several years ago. The laws changed to only include business days, so it's 15 business days. They don't provide rent or the declaration signed and documentation if they're high income and you're able to prove that, then you can evict for that unpaid rent. I haven't seen this happen very often, but sometimes tenants either they just blow it off or they think they have more time than they do. If they blow that time period, you can file at fault termination. So I'm sure you've heard about the just cause laws and different variants of that through counties and cities. But for just cause, there's at fault causes and no fault causes. You can still evict on those with some exceptions. One big one to note that I've gotten a ton of questions about because it's a fairly simple exception under the no fault causes is the remodeling cause. So previously under AB 1482, which we had talked about for a long time and really caused tends to have way more protections than they previously had. There was an exemption under there for no fault termination based on remodeling work done by the landlord. And so if you were to want to gut the property or remodel it to a certain standard beyond just repainting the walls or redoing the carpet, you could serve notice for that cause. Now, changed by AB 3088 and this bill, you have to have cause from health and safety code violation or something from the city or county or even the state saying that you have to remodel the property. So where previously it was voluntary that you did this work, now it has to be a requirement. There's some violation with the health and safety code or a local ordinance where the work needs to be done. So it can't be voluntary anymore. Some common exceptions to just cause that I want to talk about that I've been using on occasion for some clients that I think you can use as well. Housing that has been issued a certificate of occupancy within the last 15 years. So if your property has been given a certificate within the last 15 years, technically you're exempt from just cause. Another big one, and I'll read the legalese because I think it's important, is residential real property that is alienable, separate from title to any other dwelling unit, provided that both of the following apply. And number one, the owner is not a real estate investment trust and they're not a corporation. And then additionally, they cannot be an LLC in which at least one member is a corporation. So if the property owner meets those qualifications and title is separately alienable from any other unit, which would predominantly be single family properties, you're exempt from just cause. Now, it doesn't just stop there if you're exempt. There's also another thing that you have to do in order to utilize the exception is there's a form that CAR has constructed, and it's form RCJC. It's the rent cap just cause addendum, and you could easily find this on zip forms. I also can provide that for your clients if you need it. But essentially what the bill says is that you need to serve this addendum on properties that are exempt. The timing of that is dependent on your circumstances, but one way or another, you're going to have to get that to the tenants. So that's one important step that you have to take in order to be exempt from just cause and be exempt from Senate Bill 91. So there's multiple layers in order to actually be able to evict a tenant outside of these protections provided by the bill. And it's fairly complex. It's riddled with holes that landlords fall in, and there's statutory penalties if you violate the tenant's rights in these bills that are automatic, and the court will just dismiss your case if you don't meet these prerequisites. Now, city and county regulations, we talked a little bit about that, but Senate Bill 91 amends existing law to provide that any extension, expansion, or renewal by a city or county in response to COVID-19 struggles or financial inabilities by tenants shall have no effect until July 1, 2021. I think that's a super powerful change to the bill compared to AB 3088. I got a ton of questions after that passed asking, okay, the city of San Jose says this, but AB 3088 says this, which one applies? And it was fairly complicated. Now, what Senate Bill 91 does is just say, none of that applies in most part until July 1 of this year. So that makes it a lot clearer for everyone involved. And then again, they cannot extend time to pay COVID-19 rental debt beyond August 31st, 2021. So even though cities and counties can implement their own expansion after July 1, they can't extend the deadline to pay beyond August 31st, 2021. So the state kind of put a cap there saying, we get it, we're trying to provide tenants with assistance, but this is the limit as of right now. Like I said, there's a lot of uncertainty about COVID-19 and various strains and things like that. But for now, they're capping any repayment period at August 31st. I was looking at the County of Santa Clara's moratorium, and most of that won't apply, like I said, until July 1. But once that kicks in, they do have repayment periods that go beyond June 30th, 2021. So if you're in the County of Santa Clara, come July 1, we're going to be looking at another repayment period that we can talk about later on or after this presentation, wherein you would have additional time, potentially 2 more months, to repay the unpaid rent. There's different qualifications for that, and the amount owed is different than Senate Bill 91, which adds to my opinion that having multiple ordinances was very confusing. But that's what's coming down the pipeline in regards to city and county regulations. And then one of the biggest things that I can provide to you is my experience and just court realities and updates regarding the process of moving through the court. One big change that I don't think was publicized enough that I ran into issues in the very beginning was the court requires now a new form when filing evictions. So typically you have your summons, your complaint, cover sheet, your exhibits, the lease, notices, things like that. Now there's another form, it's Judicial Council Form UD-101, and it's called the Plaintiff's Mandatory Cover Sheet and Supplemental Allegations. And what this does is it talks about all these protections, 1946.2, which is just cause, different notices that need to be served, AB 3088. Now this may change again with Senate Bill 91, but the form walks the landlord through all these boxes. I think it's about 4 pages, asking if you serve the right notices, did the tenant sign a declaration, what are your causes to evict, is it for non-payment of rent? If it's not, do you have an at-fault cause? Do you have a no-fault cause? If so, did you put this language in the notice? It's fairly extensive. It's the most laborious eviction form that I've dealt with personally. So if you need help with that, or if you're trying to do self-help filing of eviction action to try to save money, I recommend seeking legal advice on at least this form. It's fairly complex, and the complaint for the eviction also corresponds to that form. So answers that you check in this new supplemental form change what's answered in the complaint. So there's a lot going on. It's not as simple as previously before all these tenant protections. So make sure that you're using the correct forms and that you're filling them out the right way. It also can be a good guideline on what you need to do in order to get there. That supplemental form that I mentioned does talk about all the notice forms required and the language required and how much time the tenant gets and the amount of rent owed. So as you're walking through these notices and requiring the tenant to do certain things, you can follow that guideline, because eventually if you do want to evict, you're going to have to fill out the form. And if you're not able to check some of those boxes, then maybe you should consider restarting or reserving notice. That way you don't get to the court and have to restart once it's rejected. So I thought that was fairly helpful. Again, I have yet to be able to get a jury trial, even though we've had ones on calendar. Jurors are hard to come by. Some counties like San Mateo, they have criminal and civil in the same court. And so civil gets priority with jurors for the most part. So any jurors that do show up for their service go to criminal. And like previously, there was plenty of jurors and there weren't any concerns about going out in public and things like that. Now it's definitely limited. They do everything they can to have you avoid a trial, try to settle the case, things like that. So if you're really trying to go forward and evict your tenant and anticipate a trial, it may not be as quickly as you think. It could be several months in some instances. Like I always state during these presentations, and I will continue to, is we always favor an amicable resolution or a settlement agreement or a cash for keys deal, something like that. Typically, the tenant wants something and you want something, and you really just need to both come to the table and discuss what can be done and what both sides have to offer. Now, if you're going to enter into some kind of agreement with your tenants, make sure that you don't violate some of their statutory rights. Some of these protections provide for relocation assistance in some instances, depending on why you're making the tenant leave or what your cause is. For example, owner move-in notices that are served, you're required to either provide 1 month's rent of relocation assistance, waive the last month's rent, and in some cases, if they have unpaid rent, you can apply that to the relocation requirement, but that they would have to have unpaid rent up to that point. So you can't enter into an agreement with the tenant where otherwise they would have more rights than what is in the written agreement. So if there's relocation assistance, if there's a statutory notice period that they're entitled to, the security deposit, things like that, you want to make sure you don't waive too many of the tenant's rights, because then the agreement could be void or they can challenge it, and then you would be in even more trouble than when you started. Like I said, notice documents are becoming more and more complicated. Make sure you're using the current forms. If anything, seek legal assistance, because if you take a look at Senate Bill 91 or AB 3088. It's extremely complex. There's ambiguities in there. It's yet to been litigated by anyone from my knowledge. So there's a ton of analysis and decisions that I anticipate coming down from the court that you can use our assistance on, or even just drafting the notice forms. We do that all the time. I myself have my broker's license, so I have access to zip forms and things like that. And I'll be checking for the new forms after Thursday if it does pass. But I think that gives a pretty good synopsis. I know that was a little fast for a whole Senate bill that's going into effect that changes the entire landlord-tenant landscape for California, but we can probably jump to questions now. Jody, if you want to read some, and I can do my best to answer at this point.
There are questions coming in, so I'm going to start at the top, just because they were some of them you may have covered part of it, but here we go. And also I want to be conscious of everybody's time. We are scheduled to go till 3. Ashley, if you're okay with it and we're still going through questions, we may go past 3. So I just want to give everybody that heads up that we will be able to do that.
Okay.
So the first question I have is, if a landlord agrees to get its assistance, what happens in the future if they still don't pay?
That was one of my initial questions when I read the Senate bill proposal. And what they're saying is that for rent from April 2020 through March 2021, that's the period wherein you can get assistance. My interpretation of the bill, and unless they state otherwise, is that for rent that's not paid from April 2021 through June 2021, that additional time period protected by the bill, you would be able to serve a 15-day notice to pay. And then if they sign the declaration form, they would have until June 30, 2021 to pay 25%. If they don't, then it would be my opinion that you can evict. Beyond June 2021, obviously that's fair game at that point without an extension, but I would serve 15-day notice for April 2021 forward, provide the declaration form, and see what they do. If they come back with a signed form, then you know you have to wait till June to recoup 25%. If they don't, then you file. But that's the way that I would approach that.
And I want to, because you mentioned this earlier, it's 15 business days, not 15 days.
Yeah, I mean, if you think about in December, if you serve a 15-day notice in mid-December, you could be looking at 3.5 weeks to a month, depending on where the court days land. And any court holiday or general holiday typically would be exempt from those 15 days. So make sure you're counting that correctly. And the days start after service. So if you serve March 1, you would start counting March 2.
I don't know if you can answer this. I'm going to ask the question because there's another one, and then I'm going to say something. Okay. So does this apply to commercial renters if only for rent not paid during shelter in place? The first thing I'll say before you jump in is, this is January. Our March Legal Tuesday topic, we will have someone coming in talking about evictions, because I believe those for Santa Clara County end March 31st, to be determined. But I will say that, and I think you can register for it, but I'll let you jump in, Ashley.
Okay, yeah. So Senate Bill 91 is meant for residential tenants. For commercial, where the protections would come in are either city or county at this point, but this is focusing on residential related tenants.
And there was another question that just got answered about property warehouses, which this does not cover. And again, my understanding, Santa Clara County is March 31st. But our Legal Tuesday, which is in March, will cover commercial. So if you have commercial, you can come back for that one and get updates there. Next question. How about tenants that are not late on their payment, but using AB 18 to prevent eviction? They were given a 60-day notice pre-COVID. It's been dragged on because the reasons is they can't find a place to take their huge dog. Bottom line, they're not late. It's not impacted by COVID. They're getting everything they got before.
Yeah, I can explain that. While Senate Bill 91 doesn't directly address that question, I think what that person is getting to is AB 3088 expanded AB 1482. I know that's a mouthful, but essentially what it said was that for most units, there's some exceptions, and I can help you that with that separately if you tell me the type of property and things like that. But for most properties, what they said is that you need just cause. So a simple no cause 60-day notice likely won't apply for most units. There's some exceptions, like I said, the single family property where the owner is not a real estate investment trust, blah, blah, blah. But AB 3088 administered just cause almost widespread. So you can't just give a 30-day notice to terminate, where typically you could before for a month-to-month tenancy or 60 days if they've been there for more than a year. You would need just cause in most instances, and then that's what I anticipate that tenant is probably utilizing is the just cause protections.
So this question, it sounds like it may be similar. I want to sell my rental and do a 1031 exchange. The tenant has not been late with their payment. They gave them a 60-day notice because they've been there for more than 2 years, but now they're using COVID moratorium for not leaving. I sent them the form to show hardship and they have not replied.
Okay, so there's a lot to unpack in that question. Number one, I would need to know what kind of property you're discussing. Even if it's single family property, not only do you have to serve the 60-day notice, but typically there's additional notices that you have to serve. I talked about the rent cap and just cause addendum that CAR has, and what it talks about is AB 1482 and subsequently AB 3088. And there's an important box on the form where it shows that you're saying that your property is exempt and that you don't need just cause, but you have to provide that with your 60-day notice, at least per the code. And so while you may have provided 60-day notice, you may have left out statutory language that is otherwise required. But I would have to assess that a little bit closer. If you didn't need cause, or if it was month-to-month tenancy, something like that, I definitely contact me. I would need more information, obviously.
So I've got a kind of a follow-up ish question to that. So let's say you have a year lease with somebody, and I think you kind of answered this, but you've got a year lease, it's up February 1st. Do you have the right to not renew that lease? And does the tenant have the right, because of all of this, to not leave?
That's a huge question, Jody. I'm glad you asked that, because if you look at just cause, so if you were curious and you want to go to AB 1482 or AB 3088 has this language, what they say is that if your property is subject to just cause protections, expiration of a fixed term lease, which you're mentioning, a defined lease term, is not cause. So it's not just cause. You would need cause separate and apart from expiration of the fixed term lease if your property is subject to the just cause protections. So, there used to be, if you're single family or certain units where the protections don't apply, AB 3088 extended that, but there are exceptions, like I mentioned. But it's important to know in your head that expiration of a fixed term lease is not cause to evict by itself, unfortunately.
Can you still give a notice and say, hey, your lease is up?
You can let them know that you're not going to renew and things like that, but technically per the CAR form lease, it states that the lease terminates automatically, and the only way it renews to a month-to-month tenancy is if you pay rent, landlord accepts, then you create a month-to-month tenancy. So if your property is exempt and the lease is expiring, do not accept rent past the expiration of the lease, because what you're doing is you'll give the tenant a month-to-month tenancy. So make sure that you don't accept rent. If they pay rent electronically or something like that, make sure you return it right away. I've had courts say that yes, we understand that direct deposit is in use and it's more common nowadays. And so you may accept it at least by way of your bank, but the quicker you return that, the better. But make sure you don't accept rent past that period. But I think the more important distinction is that, is your property protected by just cause? If it is, expiration of the lease is really not material to that analysis. It's really a matter of if you have cause, and that's not cause.
And some of you may laugh at what I'm about to say, but I watched Judge Judy, and I can't tell you how many times a landlord has accepted rent, and she says you accepted their rent, whether it was lower, whatever it was, and that, to your point, Ashley, is entering in some kind of a contract. So yep.
Yeah, the tenancy is dictated by the method of payment of rent. So if you pay for a full year and the landlord accepts, you're creating a year-to-year tenancy technically, but most people pay by the month. So it would be a month tenancy for whatever you paid for. That's what's created.
Says, I'm going to caveat this possibly. Can a landlord give a notice to a tenant to leave the house? So this goes back to something I think you said in April of in San Mateo County, you can't even give them a notice. So can you give them some kind of, like, to let them know they're on notice?
Well, if you have cause or they're not paying rent or anything like that, you can definitely serve notice, even in San Mateo County. I think what I was getting to on that is the availability of the court and things like that. But you can certainly serve notice, but the main things that you have to be careful for here are the statutory requirements as far as whether you have to talk about AB 1482, AB 3088, whether they're exempt. You have to provide a declaration form. You have to provide them notice of the Tenant Protection Act itself. So there's a whole form where you have to tell them, hey, if you're affected, these are what the protections are, even if they're not, and the time periods where they have to pay. As you can see, it's multi-layered. So the days where you could just serve a 30 or 60-day notice are all but gone. I can't think of any instance where that's allowed, because even if you do, or if you don't need cause and you're not protected by just cause, you still have to give them notice of the act, because they have to see whether they're protected or not. You have to inform the tenant because they're seen as maybe potentially not as informed about new laws and things like that as the landlord is.
And this, I'm going to ask two questions here. So what properties are exempt? And that might be a long list. And if a single family home with an ADU is rented to two separate people, so you got one in the ADU, one in the house, will it be exempt? And what if the ADU is less than 15 years old?
Yeah, so I think what they're getting at is the ADU, can they use the exemption wherein you've received a certificate of occupancy within the last 15 years? It sounds like, without seeing the lease or anything like that, that the ADU may be exempt from just cause. But the single family property would be another story, because technically we're looking at title here, and it would be a matter of, is title separately alienable from any other unit? So if on title it's shown that there's two units here, it's not separate, you may not fall within the exception for just cause. But I think that was Alice. If you have more questions about that, you want to send me the lease, feel free to. I'll type in my email to everyone so you can see that right now. Go ahead.
Ashley will put her info in the chat, and then I'll make sure to get an email out to everybody after this also, so you have Ashley's information.
Yeah.
On a month-to-month tenancy, if you want to get out of the rental business, can you issue a 60-day vacate notice? So if you just don't want to be a landlord anymore.
Yeah, so this is getting into the field of things like Costa-Hawkins and things like that, where you're removing the property from the rental market, and there's a lot of requirements for that, and then also subsequent requirements. So removing it from the rental market isn't necessarily saying, okay, I want to take my property off and not rent it for 3 months, and then I'm going to relist it, and then by that way, that's how I'm going to get the tenant out. No, from my understanding, and this is an area that I'm not an expert in, a lot of San Francisco attorneys are, because that's a big exception in San Francisco. I believe it's 3 years that your property has to be off the rental market in order to qualify. So it's a pretty big commitment. But if you did have cause, what you would do is you would serve 60-day notice to terminate tenancy, uh, or you do some kind of language in the notice for uh, no fault cause or something like that. And then you would have to state that you're utilizing the removal of the rental market exception under no fault causes under AB 1482, and you're providing 60-day notice as required by the statute and all those things. Again, I would still provide notice of the most applicable law, whether that's AB 3088 or SB 91, just to kind of check off that box, because they're going to want to see that if you do file an eviction action, if the tenant does not leave, even if the notice is not related to non-payment of rent, I always just do it. Because I am guided by the court forms and they're asking if you did serve them notice. So I think that's important. You're mute. Oh,
Yep.
there.
This one goes back to the commercial one, so I don't know answer this. Regarding the federal money rental subsidy, can the owner landlord of commercial property put in that 80% claim?
I'll get right to the point. I don't know on that yet. I know that Newsom and even Biden too wants to provide relief to all landlords, commercial and residential. But I believe that would be a separate enactment. But for now, it's mostly residential, because those are the ones that are suffering the most and that are, I mean, the way that they talk about it in the notes of the Senate bill is that this is where people live. So commercial and residential are always seen separate. There's always more protections for residential tenants than commercial, because that's where you sleep, that's where you spend most of your time, especially now with working at home and things like that. But getting assistance for someone's house is much more important to the government, at least at this stage, than a commercial property.
Couple questions on notice and on how much. So one is, if you're selling the house, you're legitimately selling and there's tenants, is it acceptable to give them a 60-day notice? And I guess this goes back to the other question, can they stay because of this whole eviction thing?
Yeah, so there's an exception. It's fairly complicated, but under just cause, and then under, I believe it's Civil Code section 1946.2, if you all want to look, where the owner has entered into a contract for sale. The buyer is going to occupy the unit, and that isn't just for a month or whatever, it's permanent residence. And then there's another exemption, I believe, if they have property that's separately alienable from any other unit. I think if you meet all those guidelines, from my understanding in 1946.2, you would be able to give 60-day notice to terminate, essentially for cause, and that would be because the owner has entered into a contract for sale. There is specific language for that exception, but you do, again, have to meet and jump through all these hoops, which it's not as clear cut as one would think.
And then just to verify, she's asking, does it qualifies as it's not on the market? It qualifies as taking the rental off the market. So which means you may give them a notice.
So I have that question come in all the time, is if I'm selling my property and the buyer is moving in, right? So technically the property is being taken off the market. That's not what's being discussed. What they mean is you as the owner are removing it from the market. It has to be for a statutory amount of time. I believe it's 3 years. Don't quote me on that. And then there's other requirements. So they make it fairly burdensome to do that and to use that exception, because as you can imagine, it would be abused if they didn't make those hurdles first.
So now I have a question. Now because you said, you can't rent it out for 3 years. So let's say, Ashley, you had a rental property and then you sold it to me. Can I turn around and make that a rental property, or does it fall under that it has to wait for 3 years?
Well, that's what I'm saying. I think it has to remain off the market for 3 years. And whether or not the transfer of title can occur before those 3 years ends, I'm not sure on that. As I mentioned, I'm not an expert on Costa-Hawkins and the related laws, which would be one of those things removing from the rental market, because they had a whole slew of landlords in San Francisco. I don't know if you recall, where they were looking for ways to get tenants out. It's almost impossible to do it. So that was an important law that passed, and that's similar to that law. Again, I would have to do some research on that to figure out exactly what's required.
Okay. Lots of questions still coming in. So if you're okay to hang, we'll just keep going until we kind of go.
Yeah, we can go for a little bit longer.
Okay. If a residential property is purchased on a non-judicial trustee's sale, does the former owner have the protections to avoid eviction under SB 91? So can you evict for cause and for that?
So short answer, in my opinion, would be no. And essentially what the lease does, or even if you don't have a written lease, the tenant's rights get assigned to the new owner. So you, as the new owner buying it at a non-judicial sale, trustee sale, if you had an exemption that would otherwise apply, that's fine. So if you wanted to buy it and then remove it from the rental market for that set duration, or you had a remodel that had to be done per health and safety code, something like that, absolutely. But those tenant rights don't, you would need the same cause that the prior owner needed. So if they have it, you typically have it, except for a few exceptions.
Okay. Let's see. So if somebody is in a property less than 2 years, is it 30 days or 60?
So 12 months or less, so less than 12 months, it would be 30.
Okay.
More than 12 months or more would be 60 days.
Okay. Does this apply to somebody renting a room, or is this only for a full residence?
Yeah, that would absolutely, that would qualify as a tenancy. It would be essentially its own separate unit. There are some exceptions where just cause is not required if the landlord also lives in the property with the tenant renting the room. Technically, you would be exempt in some cases. A single family property where a tenant occupies one bedroom and the landlord occupies another. But that doesn't mean that you're not protected by the COVID-19 rental debt protection. So the remainder of the bill would apply, but you could have just cause reasons to evict. Well, so if the tenant is affected by COVID-19 and they sign a declaration, technically you wouldn't be able to evict if they pay a certain amount, all the amounts that we discussed. But that doesn't mean you can't evict for cause for other means. If they did something wrong, or again, you had to remodel, things like that. And in some instances where they're occupying a unit, you just need 30 or 60-day notice. You don't need cause.
And you kind of answered this a little bit before. Owner needs to move back into the home. Is it okay to give a 60-day notice?
Yeah. So I just did that. I actually just did that. An owner move-in notice. Again, there's even requirements for that. How long you stay in the unit really depends on the area and things like that. For some cities, it's 1 year that you have to remain in residency. Some it's 2, 3. So owner move-in is cause to give notice to terminate, and if they don't leave, you can evict. Again, you have to provide 1 month rental assistance. So if you are giving notice, you have to give them a month back, or you have to waive the last month, or if they have unpaid debt, then you can account for that. But there's various steps, but that would be cause in most instances.
Okay. So it looks like somebody has a single family home that the lease is expiring on, February 1st. At first they said, no, we're not going to move out, but they later did not move out, signed a new lease, but they didn't pay the rent.
Yeah, so you would, I mean, arguably, I would never give this advice, but it sounds like on what you're saying, it sounds like you can evict. But again, if they end up being protected, which it doesn't look like they are, you could still serve a notice to pay. Key things, Simon, is that you don't accept rent. Like I mentioned, do not accept rent because you'll create a periodic tenancy, and then you'll either have to give 30 or 60-day notice. But it sounds like you may be primed to evict them if they haven't moved and you haven't renewed, and the lease does terminate automatically. But again, you may have a few options, so you may want to reach out.
Okay. And we'll get through the questions before I get to some of the reference ones. If a property is not yet on the market and there's no contract between a buyer or a seller agent, can you give notice in anticipation for?
I would say no by read of the statute. What it's saying is that owner has entered into contract, buyer plans to occupy the unit, and you're exempt under certain code sections. If the AB 3088 mentions it pretty specifically. I think why they do that, and this is just my opinion, is that you want that contract in hand because in the car contract or PRDS, it says if the buyer intends to occupy the premises. So it's not just this anticipation where the contract terms can change. I think if you actually have an executed contract in hand and you're able to prove, yeah, look, the buyer intends to occupy it as their permanent residence, then you may be able to use that cause, but I would wait until you actually have a contract. At least that's the way the statute reads.
Okay. I heard the eviction process is not impossible because the sheriff is not participating in evictions at the moment.
Yeah, I actually had firsthand knowledge of that as well. And I have a funny story, not really funny, but I was impressed by this story from a client that we had. So I got a writ of possession. I went through the whole eviction. Slam dunk as far as evictions are. And I gave it to the civil unit of the sheriff's office, and they said, no, we're not processing these. And I kind of, I was a little confused. And essentially what was going on is that the sheriff's office, just like everyone else, was seeing all these new laws come in, these protections. All you see on the news is eviction moratorium. That's all you see. You don't see the exceptions, or you actually get through the court and they give you a judgment. That means you have a right to evict. And so what my client did is she contacted a local official who got in contact with the sheriff's department and sort of clarified the situation. We were able to process the eviction. So I think now, more than before, I'm not sure when this information is based on, but previously that was an issue, but it sounds like we've cleared that up. I think the sheriff's department just was confused like everyone else about what they're able to do and what they weren't. So they just decided that they weren't going to violate any tenant rights. But now it's been clarified that, yeah, you can, and there are exceptions. So I haven't had any issues, but maybe I've had it easier than others. I'm not really sure.
And it sounds like really the only really reasons are health and safety at this point.
Well, no, I mean, if you can evict a tenant, so if you serve a 15 notice to pay, they don't pay and they don't provide a declaration, you have cause to evict. If they're breaking the law, you have cause to evict. You can evict. Any breach of the lease, anything like that, and you serve a notice to cure and they don't do it, you can evict. We're still filing and processing evictions. It's just a matter of if they're protected or not. I wouldn't think of it necessarily as a way of it's not possible or it's only for this cause. It's just a little bit harder if it's based on non-payment. And even then, don't be hesitant on serving your notices. If you're a landlord, you do have the right to make them pay or make them provide a declaration. Don't just let them kind of slide by and not have to do anything because you fear that you're not doing the right thing. Seek legal counsel and get these notices out, because at least you'll know and put the pressure on them that, yeah, they are affected or they're not. Maybe they haven't. A lot of people have still worked and been blessed enough to be okay, but I would get the notices out and at least make sure that they are protected before you make that conclusion.
Yep. So a couple just reference questions. What website can a landlord apply for the federal 80% of the rent claim?
I haven't gotten that information yet just because the bill hasn't passed yet. I presume on Thursday we'll know more. So I would check just wherever you get your news or anything like that. Um, uh, Twitter usually has a ton of information. I know it's not legal advice, but I think on Thursday they'll start administering at least the submission plan. And from my understanding is that you could start getting relief as early as March. They want to make this stuff really available for people because as homeowners, you're struggling paying the mortgage. Not everyone, has multiple properties where they can subsidize non-payment by one tenant with the other. If, a lot of people rely on that rental income to pay that mortgage. So they're struggling. They want to get this money in landlord's hands fast.
Yep. Is there a list of just cause?
Yes, there is. So there's 12 causes, 6 no fault and 6 at fault. At fault are things like non-payment of rent, breach of the lease, unlawful activity, things like that. No fault or owner move-in, removal from the rental market that we talked about. If you just do a simple Google search at AB 1482 or just cause at fault, no fault causes, usually you can find it pretty quickly. I can send you that list if you'd like. I have the full list available. Just let me know.
Yep, if you can send me that, and then I'll make sure to follow up with everybody.
Okay.
Oh, here's an interesting question. So I'm assuming lease is up, or they're saying, here's my 30-day notice, I'm moving out, and then they don't. Do you still have to serve them a notice, or is it straight to eviction?
So if they give notice and don't move out, do you have to give?
Right.
Yeah, it's that one to me. I only hesitate because my only doubt on that one, Angela White, is that they haven't received any tenant protection notices or language. But I think that essentially what you may be looking at is it would be the same as by operation of a fixed term tenancy. So like I said, when the lease automatically terminates, you don't accept rent past a certain period, you probably have grounds to evict automatically. I would just want to make sure that the lease doesn't state anything differently, and that one very important exception that you have to know, Angela, and I've noticed this in the settlement agreement blurb, is that make sure that the tenant didn't waive any statutory rights. So if they gave you 20 days notice that they're going to leave, or 25, something like that, and they're actually entitled to more, like 30 days or whatever the case may be, it may not be valid notice. So you may want to contact me just so I can clarify to see if you are ready to evict on that action.
Somebody e-filed a UD on the court website.
Mm-hmm.
What's next?
Serve the tenant. There's a couple ways to serve: personal service, substitute service. We could talk about that all day. And then tenant can answer the complaint or not, depending on what they do. You can get a default judgment or you go to trial. That's really what's coming up next. But I would say make sure you serve the tenant.
Can you ask for an increase in rent after a year, 5% per lot? So and I'm going to say this probably during this time, can you still increase rent?
Yeah, there's statutory requirements that you have to give. You have to give a certain time period of notice, either 30 or 60 days, depending on the amount. But in some instances, you could do 5% plus CPI. So it's the consumer price index increase for the year. So I've seen it anywhere from 7 to 8%. You could actually increase, but you have to give ample notice and you have to give written notice. You can't just email or text the tenant. You have to actually serve written notice. So in most instances, yes, but of course, that would be dependent on the particular lease. You can't increase the rent during a fixed term lease. So just make sure you don't violate that.
Okay. What's the name of the CAR form for getting notice?
They're not going to like that answer, but I don't use the CAR form for 60-day notices. And I'll explain why. I have my own custom forms because for most 60-day notices now, you need cause and you need to be specific. So typically the CAR form isn't as specific as I would like, just come from my perspective as being an attorney. So say if you're evicting for something like remodel, right? I'll put in there 60-day notice to terminate for just cause, and I'll describe, owner has been notified by the city of Palo Alto that this work needs to be done. Accordingly, we're serving notice pursuant to the, whatever requirement is stated in the lease or the law, and I would serve it that way. So like I said, it's pretty involved, and you want to be as specific as possible in your notices. And sometimes the form notices just don't cut it. At least for that type, I wouldn't use that.
I'm going to take one more question and then we'll wrap it up just because we're about 15 minutes over. If I have not, you haven't given any notices, but they're paying half their rent, what do you do?
Yeah, so serve the 15-day notice. So if you go to the CAR form, 15-day notice to pay, depending on what the time frame is, it has a very cool Excel style accounting where you put what the rent is owed and what they've paid, and it'll calculate it for you for each month. And so anything short of the full amount, you can give 15-day notice for. Sorry about that. And if they don't pay the full amount, serve notice, and then they either have to pay that amount or sign the declaration, and they still have to pay 25%, which it sounds like they'd be fine for that month. But yeah, I would serve notice right away, put the pressure on them, and either make them sign the declaration or pay the rent.